Hello and welcome to our 28th webinar. So we're imagining that our 30th webinar might become our great Christmas quiz. Just wait and see. So I'm Sue Farmer from the MCA team. Got presentations today from Natalie Wakefield, Val Cope and myself. Natalie has pre-recorded her presentation because she's not able to be with us today. So we're going to kick off with Nat's presentation, and she's going to be talking about lasting power of attorneys and the sort of the authorities that are invested in those. Then Val is going to talk about assessing capacity and looking at some of the more complex issues around longitudinal capacity and fluctuating capacity. And then if there's time, I'll do some case law at the end, but we've got quite a packed programme to get through. I can see that we've got about 43 people watching at the moment, so we'll probably get started. So I'm going to just wait for Rhiannon to key up Natalie's presentation, and bonus points if you watch out for Barbie and Harry Potter all featuring in the presentation. So I hope you enjoy it. Be there very shortly.
Hi everybody, my name is Natalie Wakefield and I am one of the Mental Capacity Act advisors. I am here as a pre-recording today because I wasn't able to be there in person for the live. So if you've got any questions, ping me an email and we can have a chat about those. Or Val and Sue, they are here live today, and if there's time for Q&A at the end, they might not mind answering some questions, but you know, I will be around, you know, kind of like during my usual office hours if you want to give me a ring or send an email. So I'm going to talk today about lasting powers of attorney and what their powers are. So before I continue on, I thought it would be helpful to start by looking at some acronyms that are usually used when we're talking about powers of attorney, etc. Seems as though health and social care love an acronym, and I don't know what half of them are. So I just wanted to go through these to make sure that there's no confusion as we're moving forward with the rest of the presentation. So MCA usually stands for Mental Capacity Act. LPA, Lasting Power of Attorney. LPA for H and W usually stands for Lasting Power of Attorney for Health and Welfare. LPA for P and F is usually Lasting Power of Attorney for Property and Finance. And you may see still some reference to EPA, which is Enduring Power of Attorney. So that was pre the Mental Capacity Act, and an enduring power of attorney is only given decision-making responsibility in regards to finances. So it was never concerned with any decisions related to health and welfare. So we will move on to what is a lasting power of attorney. So an LPA is a legal document that lets the donor appoint one or more people, known as attorneys, to help the donor make decisions or to make decisions on their behalf. So the purpose of this is really to give the donor more control over what happens to them if they have an accident or an illness and they can't make their own decisions, so they lack the relevant mental capacity. To be able to write an LPA, the donor must be 18 or over and have the mental capacity at that time to instruct an LPA. Okay, and there are two types that people can draw up, and that is a health and welfare and or a property and financial affairs LPA. And people can decide to do one or both. It's totally up to them. So I am going to be focusing on LPAs today, but I thought it might be helpful to just have a very quick look at deputyship. And that's where a person can apply to become somebody's deputy if that person lacks the relevant mental capacity. So the LPAs, the person, the donor themselves, they are the ones that write up the LPA. Okay, so they're the ones making the decision because they have the mental capacity at the time to do that. Deputyship is for when the person lacks the relevant mental capacity, so somebody else is making the application on their behalf to take over that decision-making responsibility. And they have to make they have to do this application to the Court of Protection. And there are two types, the same as there is with LPA, so property and finances, health and welfare. And if the court appoints them to be the deputy, they will then get a court order saying what they can and cannot do. And a deputy must also send an annual deputy report to the Office of the Public Guardian explaining the decisions that they have made. It's kind of like an extra level of scrutiny there. And I think that's really because, unlike the LPAs, the person themselves hasn't made this decision. So we need to make sure that that the person who is now making decisions is making the right ones, and the OPG will oversee that. So a few quick considerations in regards to LPAs. It has to be registered for an attorney to act. So please, 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 if you are supporting somebody and somebody comes on and says, there is a lasting power of attorney, I'm one of the attorneys, so I can make decisions on behalf of this person, please see a copy of the registered documents and save them onto whatever systems it is that you are using, so then other people are able to see that there is a registered LPA in place. So as an attorney, they must comply with the principles of the MCA. They need to have regard for the code of practice, and they must consider the donor's past and present wishes, feelings, beliefs and values. So that may all seem very simple to us because we work with the MCA, don't we? But to somebody who doesn't work within health and social care, they might not know what the Mental Capacity Act is. When you agree to be somebody's attorney for health and welfare or property and finance, you get a letter from the Office of the Public Guardian, and it says that by agreeing to be the attorney, you must comply with the principles of the Mental Capacity Act, etc. And they provide a link on the letter so you can, you know where you can go to get some more information. I don't know how many people who agree to be attorneys look into what the Mental Capacity Act is, what the principles are, if they have any idea about what's written in the code of practice. Some might not. So I think it's just really important, to be aware of that and to consider that, when you're talking to attorneys, because they might just need a little bit of help and guidance from yourself when it comes to decision making and how they reach decisions. Because if they've never heard of the Mental Capacity Act, then when they're talking to you, it's going to be really difficult, isn't it? For them to be able to evidence how they've reached certain decisions and to ensure that person's wishes and feelings are really being kept central. So what decisions can be made? So we'll go through property and finance first. So one decision that they could make is regard to buying and selling property. I'm sure that no one that we work with will own Hogwarts, but if they did, then their attorney for property and finances could make the decision to sell it. They can make decisions in regards to opening, closing or operating any bank, building society or other accounts. So if they've got a particular aversion to goblins, they may decide to move the donor's bank account from Gringotts Wizarding Bank to NatWest because they prefer the people that work there. They can give access to the donor's financial information, and they can claim, receive and use benefits, pensions, allowances, rebates on behalf of the person. Now, if there is already an appointee appointed by the DWP, then it's really a decision between the LPA and between the attorney and the appointee as to whether the appointee carries on with their role. So the appointee can continue on with their role, and then the attorney for property and finances can sort out everything else. Also, when we're talking about receiving things on behalf of the person, it's really important that everybody understands that doesn't mean that the attorney keeps all of that for themselves. They're receiving it on behalf of the donor, and then they spend it on behalf of the donor for the donor. So they don't, it's not now their money to spend as they wish. So the same goes for receiving any income, inheritance or other entitlement on behalf of the donor. They can deal with the donor's tax affairs, paying the donor's mortgage, rent, household expenses, make decisions in regards to ensuring, maintaining and repairing the donor's property. Again, it's a place like Hogwarts, that's probably quite a lot of maintenance to have to manage. So you can see here that the responsibilities for the attorneys is really starting to amount up, isn't it? So they can make investments with the donor's savings, they can make limited gifts on the donor's behalf. And an important thing to note here is that gifting is absolutely fine as long as it's something that the donor had done previously. You know, Harry Potter may have liked to gift Hermione and Ron a present on their birthday. He now lacks capacity to make decisions in regards to his finances, and his attorney says, well, actually, he's always done this, so here is the money to enable that gifting to carry on. That's absolutely fine. If it's gifting to people that they have never gifted to before, something that seems quite unreasonable and quite extravagant, then that's something to look out for, consider, and think, is this something that we need to look into a little bit more. So an attorney can pay for private medical care and residential care or nursing care fees. They can apply for any entitlement to funding. They can use the donor's money to buy vehicles or equipment or any other help that the person may need. And again, it's really important that these are items for the donor. They're not items for the attorney. And lastly on this list is repaying interest and capital on any loans taken out by the donor. So this list has been taken from the Code of Practice, and the Code of Practice makes it clear that this isn't you know, the final list of decisions that an attorney can make. Okay, so you know, everybody is unique, their circumstances are unique, but it just gives you an idea as to the types of decisions that an attorney, property and finances can make. So next we'll move on to health and welfare and what decisions can be made under this. So first on the list here, we've got where the donor should live and who they should live with. So let's think about Barbie. She has lived her independent woman lifestyle in her dream house. Well, if she lost the mental capacity to make decisions about where she should live, do you think that she would want to move away from her dream house? What if Ken has offered to move in and take care of her? Do you think after a lifetime of living independently, she would want Ken moving in and taking care of her? You know, this is where we are considering the person's previous wishes and how they have lived their life, and how attorneys need to be thinking when they're making decisions about the future of somebody's life. So there's also decisions about day-to-day care, including diet and dress. Again, let's think about Barbie. She's always taken a lot of pride in how she looks. I can't imagine for a minute that she would be happy wearing some beige trousers and a white tee. You know, she wants to be wearing the glamorous, fantastic outfits that she's always worn. So actually an attorney needs to be supporting that through her future when she isn't able to make those decisions for herself. So next on the list here, we've got who the donor may have contact with. Now, I didn't realise that this was a decision that an attorney for health and welfare could make until a year or so ago. And I think it's just one aspect that we need to pay particular consideration to, and how that restriction of contact may impact on their human right to a private family life. You know, if you do have concerns about any restriction of contact, talk to the attorney about it. You know, it doesn't have to be contentious. You know, just use your people skills. You know, find out about the reasoning behind it. Has it come from a place whereby the attorney is thinking about the donor, or has it come from a place whereby the attorney is thinking about their own thoughts and feelings about the person who has been restricted contact with? So a health and welfare attorney can also make decisions in regards to consenting to or refusing medical examination and treatment. They can make arrangements to be given medical, dental or optical treatment. They can make decisions in regards to assessments for and provision of community care services, whether the donor should take part in social, leisure activities, education, training. They will make decisions and look at the donor's correspondence and papers. They can also make decisions in regards to rights of access to personal information about the donor, and also make complaints about the donor's care and treatment on their behalf. So again, you know, this isn't an exhaustive list. It's a list from the code of practice, but like I said before, everybody and everybody's situation is unique. So we need to take that into consideration when we're looking at the decisions that an attorney is able to make. So what decisions can't be made? So in regards to property and finances, if there is only a property and finance LPA, that attorney cannot make decisions about the person's health and welfare. They also can't make decisions in regards to property and finances if there are decisions or restrictions that the donor has included in the LPA document. This is where it's really helpful to be able to see the full document, because that's where the donor will have recorded any of those restrictions, or how they want decisions, how they would like decisions to be made. Attorneys have no authority to take actions that result in the donor being deprived of their liberty. They may feel that a decision is in that person's best interest, but it doesn't give them the authority to deprive them of that liberty. Okay. So decisions also can't be delegated unless they're authorised to do so in the LPA document. And decisions must be lawful. Okay, so attorneys can't make decisions in regards to property and finances that break the law. So what decisions can't be made in regards to health and welfare? So again, they cannot take action which will result in the donor being deprived of their liberty. So they may feel it's in Barbie's best interest to move into X residential home. Barbie doesn't want to go. We follow through with our usual legal processes, whether that's under the deprivation of liberty safeguards or if it's under section 16 welfare application, depending on where Barbie is at the time. So if the attorney only has LPA for health and welfare, they cannot make decisions in regards to property and finances. If there are decisions or restrictions in that the donor is included in the LPA document, and again, the attorney needs to be aware of those. They should have read the documentation and be aware that there are those decisions or restrictions written by the donor within that documentation. And an attorney cannot make decisions on behalf of the person that are classified as excluded decisions under the Mental Capacity Act. So I'm going to move on to these next. And by excluded decisions, what I mean is that nobody is authorised to make best interest decisions on behalf of somebody in these areas that you can see here up on your screen. So you or I, attorneys, the court of protection, we just cannot make best interest decisions on behalf of people in regards to these. So when it comes to decisions concerning family relationships, what we can't do is make a best interest decision to consent to marriage or a civil partnership. We can't make a best interest decision consenting to have a sexual relationship. We can't make a best interest decision consenting to a decree of divorce on the basis of 2 years separation. And again, the dissolution of a civil partnership. Can't make a best interest decision consenting to a child being placed for adoption or the making of an adoption order. We can't make a best interest decision to start discharging parental responsibility for a child in matters not relating to the child's property. And we can't make a best interest decision giving consent under the Human Fertilisation and Embryology Act 1990. So when it comes to Mental Health Act matters, where a person who lacks capacity to consent is currently detained and being treated under the Mental Health Act 1983, nothing in the MCA authorises anybody to give the person treatment for a mental disorder or consent to the person being given treatment for mental disorder. So if somebody is detained under a relevant section of the Mental Health Act, you can't use the Mental Capacity Act to provide that treatment because it's already being authorised under the Mental Health Act. So then we move on to voting rights. So nothing allows a decision on voting. OK, so we can't make a best interest decision on behalf of somebody to vote for a certain party. OK. And unlawful killing or assisted suicide. So nothing in the MCA affects the law relating to murder, manslaughter or assisting suicide. We cannot make best interest decisions for people to engage in any of those acts. OK, so they are the list of excluded decisions that none of us are able to make on behalf of people. So lastly, how are best interest decisions made? If there is a registered power of attorney, then they are the decision maker. So the attorney is the one that has the responsibility for demonstrating how they have made decisions in the donor's best interest. So there doesn't have to be a best interest meeting. But what you could do is record these decisions in case notes, so you and future workers can see what decisions have been made and by who. I think it's really useful to be able to see that, so we know, like, oh, okay, so that decision was made then, and this is how the attorney got to that decision. We have a record of it as well. It's just quite helpful. For more complex decisions or contested decisions, you know, if social care and the attorney are reaching different decisions, it may require some more formal documentation from yourselves. Speak to the MCA team or legal if you feel it's appropriate about your concerns. Talk to your management, colleagues, etc. And in these circumstances, you know, you should really be providing some support to the attorney to arrange best interest meetings, possibly using the balance sheet, writing up that best interest paperwork, because I think that process, that collaborative process, really helps all parties involved to be able to see the viewpoints of everybody that's concerned with the person's welfare, you know, that person at the centre. I think it's quite rare for attorneys to be making decisions that they feel, you know, really aren't in the person's best interest. You know, they do genuinely, I think, most of the time have that person's best interests at heart. They come from a perspective, most of the time, from having spent, you know, possibly a lifetime with the person. They know that person. That person trusted them to make decisions on their behalf when they had capacity to draw up this LPA. When it comes to family members, you know, being LPAs, a lot of the time they come from a perspective of wanting to keep that person safe, and wanting to keep that person safe comes from a place of love. We come from a different perspective because we don't love the person. We, through our training and our experience, maybe have a more holistic view of situations. Our primary focus isn't necessarily on safety, but we also look at all the other areas of well-being that we know are very important to people. So if we can all sit down in those situations where we're struggling to reach an agreement and talk about where we're coming from and why and how we are looking at it from that person's perspective, then it may be that we can reach some kind of agreement about what is in that person's best interest. Because also attorneys, like I said at the beginning, might not be familiar with the Mental Capacity Act. So being able to provide them with that support, that advice and guidance might actually be really helpful for them to be able to make a more informed decision about what is best for the person. But if you do have any concerns about how an attorney is making a decision or decisions that they have made, you've got lots of possible avenues of support, you know, your manager, the MCA team, your legal services, safeguarding, the Office of Public Guardian, you know, reach out, talk to people, because at the end of the day, we all want what is best for the person, and so do attorneys. We can just sometimes come at things from different perspectives. And that's not necessarily a bad thing, you know, all coming together and being able to really make that holistic decision and get all the information is really important. So that is all from me. I hope it's been helpful. Like I said, if you've got any questions, send me an email because I'm not here in person today, and I'm sorry again about that. Or have a chat with Val and Sue at the end if there's time. Take care, everybody.
So we've just got
So we've just got a quick delay while we get to the next bit of the presentation. And there we are. So I'm going to take control of the slides, hopefully, if I can. And my name's Val Cope. I am one of the advisors with the Mental Capacity Act team. And my remit today is to talk about capacity and fluctuating, longitudinal and anticipatory was were the topics I was given. So not being one to back away from a challenge, I'm going to give it a go. It's going to be a bit of a whistle stop because we don't want to run out of time. So I'm going to start right in with a case law about that you might be familiar with this because it's probably come up in other bits of training before. I think this is the next slide, isn't it? This is about a person, a 68-year-old woman, AG, who had a frontal lobe dementia, who was struggling to manage at home. And she went into a care home for respite, where she formed an intimate relationship with another resident. And the two of them both talked about getting married. Now, the background to AG is she had been married 4 times. She had 4 children and 18 grandchildren. She'd been living alone in a bungalow as a local authority tenant prior to moving into the care home in 2019 on an emergency respite basis. She continued to reside there nearly 17 months later. She'd had episodes of confusion, aggression, behavioural changes. She'd run out of her house. She'd been found naked outside her bungalow. On one occasion, she'd smashed neighbours' flower pots, lost her keys, handbag, passport, bank cards. And then a further incident in July 2019 resulted in her admission to the care home. And she does not accept that she needs to be there. CI, on the other hand, who is the other party, had been admitted after a stroke. Now, this chap had been left as a wheelchair user, but he was cognitively intact, and AG and CI had formed an intimate relationship and they wanted to marry and live together. However, AG was found to lack capacity for sexual relations and AG disagreed, and she wanted to remain at home. So this was a case where this is a person whose capacity was thought to be lacking in that area. And therefore, it went to the Court of Protection, and there was an expert who was asked to assess capacity in several areas. And these are all the areas that the expert was asked to assess. So paragraph 4.16, I should say, of the Code of Practice says that it's important not to assess someone's understanding before they've been given the relevant information about a decision. And we are supposed to be providing people with information so that they can make a decision if they're able to. And the court actually they weren't very happy with the report that came from the expert, because what they said was it didn't provide sufficient evidence that AG had been given the relevant information in each decision. So they'd sort of come at it as a whole, looking at capacity sort of in the round, rather than looking at each specific decision. And the reason I've sort of picked this out is because this might be relevant to us when we're doing capacity assessments. We need to be giving people information, and we need to make sure that they have the information for the different areas. So what might cause fluctuated capacity? Well, there's a whole list of things that you've probably already heard of, but the things that are sort of seem to be coming in my experience more now, are things like coercion by others, and we're getting case law around that. And also, people's levels of anxiety can sometimes affect their capacity. So it's not just about having a cognitive impairment, as you know, we would recognise it, dementia, learning disability, something like that. But there are other areas that could influence whether or not somebody has capacity. So I'm going to look at another bit of case law now, and this is about the limits of decision specificity. Is that how you say it? I don't know. So we've said now that the decisions have to be kind of separated out. So you're only assessing capacity for an individual decision, but some decisions can be grouped together. So, for instance, in this case, again, capacity was being looked at for several different areas, including the conduct of proceedings, as well as management of affairs, residence care, contact with others, use of social media. And this was a young woman who was in care and was engaging in some risky areas. And what the judge said in this area, in this case, was that it's artificial sometimes to pigeonhole these decisions into separate decisions, because sometimes they're deeply interrelated and have to be considered in the round. And the judge said it would be wrong in the case of CMW not to consider things like residence and care together, because one impacts on the other. So there are some things you can sort of group together and some things you can't. I'm not making it any clearer, really, am I? What he said was it's her fundamental inability to grasp why she needs support and what would happen if she didn't have it that underpins the finding that she lacks capacity in both of those areas, and that's why they can be grouped as one sort of decision, really, the care and accommodation. So in this case, CMW's potential capacity did fluctuate, and that depended on whether she was calm or distressed. But the judge said even when she was at her calmest, she didn't achieve the level of functioning that would amount to having capacity, in particularly in regard to residence and care and contact. I did say this is going to be a bit of a whistle stop, didn't I? So my next bit of case law, and this is one you've heard of before, and my only excuse for putting it in again is so I could put a cute dog picture in, basically. This was a lady who was 63 years old, and she had a diagnosis of personality disorder and diabetes. So she had a mental disorder and a physical problem, both of which were impacting on her capacity, partly because she wasn't managing her diabetes very well, that this was affecting her thought processing. So initially there was a judgment made that when her mental health was stable and she was managing her diabetes really well, then she had capacity. But when she was unstable, then she lacked capacity, and everybody kind of threw their hands up at that at the time, I remember. So this was the case law that said about the tail of welfare wagging the dog of capacity, which is why you get the dog picture. This case then went on and was heard again, and of course it brings us to the macro-micro decisions case law that I'm sure a lot of you have heard of. And this was a different judge, Justice Newton, who said that there might be occasions when CDM had the capacity to make micro decisions in respect of her diabetes. So sometimes she could manage to, monitor her blood sugar, to make sure she took the right medication, and that she was sort of doing okay with it, but other times she didn't, particularly when her mental health was poor. And that meant that her capacity did fluctuate, but if you were looking at this in a logical and practical sense, it became a macro decision. You couldn't expect to do a capacity assessment every single time that a decision needed to be made around diabetes, because that could be several times a day. So the judge said in the macro area, the issue of fluctuating capacity simply didn't arise, it just fell away, and that she overall lacked capacity. So the next bit, longitudinal capacity. So I did find a bit of case law for this as well, and this is Cheshire West and Chester Council v PWK. Now PWK was a young man with autism and a mild learning disability. Cognitively, he was quite able a lot of the time, but what he did have was severe anxiety, and his anxiety could be so severe that at times it impacted on his capacity. And some of his actions and statements that he made during those times when he was highly anxious were not great decisions. But when he was calm, he was able to make decisions. He wasn't in residential care. He was under a community deprivation of liberty order because he was in supported living. And again, the court was asked to make several capacity rulings on accommodation, care and support, social contact, social media and internet, and money and property. And in this case, the court decided that, yes, there were times when PWK was calm, he was able to think things through, but the unpredictability of his anxiety, this had such an enormous impact at times on his decision making, meant that in order to make ongoing repeated decisions, he overall lacked capacity. And Sir Mark Headley, who was the judge there, said that in the context of this evidence, he was not satisfied that he had capacity. And he said that this has been referred to as taking a longitudinal view. So looking at ongoing decision making rather than just in the here and now. So I'm sorry this is going a bit fast. So now we're on to anticipatory, and I found another bit of case law for this. So this was United Lincolnshire Hospital Trust, VCD, and this was a case of a woman with schizophrenia. Again, you may have heard of this because it was 2019, so it's probably been cited in other webinars. This lady was detained under the Mental Health Act. She was pregnant and there were questions about the arrangements for her birth because it was felt that when the time came that possibly there might be a risk that it will all go horribly wrong. And this was based on this lady's history, that the clinicians who knew her well thought there was a substantial risk, and the judge agreed. So the judge said that if they failed to address the matter now, they could put the welfare and even the life of CD at risk, and also possibly the life of the unborn baby. So the Justice Francis held that where the circumstances under the woman would lack capacity about the birth arrangements were sufficiently clear, it was possible to make a contingent declaration about what would happen. So in anticipation of things possibly going wrong, the decision was made that at that point, if she lacked capacity, then clinicians could step in and make a decision, because they knew that they weren't going to have time to rush off and get a court order, you know, in the moment. So I'm now back to fluctuating capacity again. Now this was an interesting bit of case law. This was A, B and C v X, Y and Z. I should have said Z, shouldn't I? Then it would have rhymed. This was Justice Headley. Now this was a chap who was an older man who was he was pretty well off, and he'd had he was described as being a substantial means because he had a family business and all his family were involved in it. His former wife had died after 56 years of marriage in 2008. Now he had 3 children, that's A, B and C, and they all had LPA for health and welfare. By 2007, he was tending to forget things and wasn't really sort of managing his affairs very well. And his business administration was taken over by Mrs. B. Now, Mrs. B is clearly a daughter-in-law because A, B and C were the sons. So, so his affairs were being managed effectively by somebody else. And then in 2008, after his wife died, he was diagnosed with dementia. And by September 2008, he'd executed lasting powers of attorney in favour of his children. And then in 2010, Z came on the scene. Now, Z was employed as his carer. But by October 2010, X had decided that he would like to marry Z. And relations between Z and the family rapidly deteriorated after this. So this went to court, and Justice Headley was asked to make decisions on capacity about whether X had the capacity to marry, to make a will, to revoke or grant an enduring or lasting power of attorney, to manage his affairs, and to litigate. So again, he had to take all of these things separately. And what he said was, looking at the decision to marry, as you'll know from previous webinars and things that have come out before, the capacity to marry is quite a low threshold. You have to understand that it's a contract. You have to understand that you know what is involved is that you live together and that you share things, and it's a fairly straightforward one. I mean, he'd been married for 56 years, so he had an understanding of being married. So the judge said yes, he thought he did have, certainly at that point, the capacity to marry. However, when it came to some of the other areas, particularly around his the management of his affairs, it was thought that possibly he didn't really have capacity because his affairs were quite complex. He had all these business interests that were, you know, the day-to-day running, but when for instance, something unexpected would happen or there needed to be a decision made that wasn't expected, possibly he would struggle with that. So there were areas where he was thought to have capacity, and there were areas where he was thought not to. But on the whole, he had a sort of fluctuating capacity, but he really didn't, he wouldn't manage things that were possibly unpredictable or needed an urgent decision. So that is X, Y, and Z. And I'm now going to hand you over for the last bit of the webinar to Sue, and Sue's going to do the ever helpful case law update.
Hi. So I've got less than about 10 minutes to do a case law update. So I've only chosen 2 cases, and I've picked them really because they both tell us something interesting. So this case was an NHS trust, and it was, you might have seen the headlines, but it said, when does not believing your doctor shade into incapacity? So that was the kind of headlines behind it, but it's the background to it is a very, very sad case. I'm galloping on already. So this is about a 19-year-old woman who's got a very rare mitochondrial disorder, which is sadly a progressive and degenerative disease. So she spent much of the last year in an intensive care unit. She is medically ventilated through a tracheostomy. She's fed through an endoscopic gastrostomy tube. She has regular dialysis. She's got impaired eyesight and hearing loss, chronic muscle weakness, bone disease, and damage to her kidneys and lungs. So this poor young woman is very poorly, and what's happened is the treating team that are caring for her have collectively come to the view that she's fast approaching the end of her life. So the trust that are caring for her's plan was to move her to a treatment plan, more palliative care, so it would be less invasive than the current treatment. So the dialysis would end. There'd be no further attempts at resuscitation in the event of a major respiratory arrest. And they knew they needed to involve her in those decisions as much as they possibly could. And they wanted to make steps to make sure that her last days or weeks of her life were comfortable and as pain-free as possible. But she had some very different views. She told the doctors essentially that she wants to do everything she can to extend her life. She recognises that she might not benefit from further treatment, but she and her family had found some experimental nucleoside treatment, which is available outside of the UK and Canada or North America. But she did recognise that treatment might offer her hope of an improved quality of life, but it would still probably mean that her life expectancy was less than usual. But what she did tell the doctors is that she wants to die trying to live, and that they have to try everything to try and keep her alive. So the trust sought declaration that she lacked capacity around her care and treatment. They had 2 psychiatrists that from the trust, so they weren't specially designated psychiatrists, they were trust psychiatrists who assessed her capacity, and they said that she had capacity, and they both said the reason they found her to have capacity is that there was no recognised impairment or a disturbance of the functioning of her mind or brain. the consultant leading her care said that she was unable to weigh up the pros and cons of a dignified death because she felt that they felt that she was suffering from a delusion derived from a false reality that she cannot contemplate her own death. And I think, to be fair to her, she kind of confounded treatment expectations to this point. So I think she had reason to not terribly believe the doctors. And what the judge found is that she is aware of the nature of her disease. She knows it's very rare. She knows she's one of the very few people in the world to have it. She knows by its nature it's progressive, and at some point in the future she might succumb to the effects of it and die. But what she doesn't understand is the precariousness of her current prognosis. So we've got a treating team who are saying she's going to die imminently, and she's not believing that. But as I said, one of the reasons she's not really believing that is because up to now she has confounded their expectations, and she's lived through episodes where they obviously felt she was pretty close to life. The judge is satisfied that the doctors are telling the truth, that she's not suffering from the long effects of COVID, that this is because of this kind of tragic condition that she's got. But she clings to the hope that doctors are wrong. And I mean, who can blame her? And she's only 19. She doesn't want to die. She's terrified of dying. She's basing her decision on the basis that any available treatment is better than palliative care, so doesn't want to let go of that hope. She doesn't believe what the doctors are telling her, and she doesn't understand what might be involved in pursuing this experimental treatment. And she's also failed to factor in at this point that there are no concrete offers of that treatment on the table at this point in time. So she can't make the decision. She doesn't believe the information that the doctors have told her. They've said, the judge said, this is very different from making an unwise decision, and the difference being that an unwise decision involves the juxtaposition of both the overview of the wisdom of the decision, of acting in one way or another, and sort of subjective reasoning for informing that decision. So actually knowing and understanding that you're making a decision and it's unwise, and the judge said that she's not making an unwise decision. She doesn't understand that it's an unwise decision. So coming on to the impairment or the disturbance of the functioning or mind or brain, which was the sort of sticking point. Interestingly, the MCA itself doesn't require a formal diagnosis. We do know that. And the court just has to be satisfied that the person lacks capacity in relation to the specific matter. And it's not defined in the Mental Capacity Act. So the court is entitled to have regard to a wide range of factors that may affect an individual case, impairing functioning of the mind or brain. And most importantly, the intricacies of the causal connection or the causal nexus between that lack of ability to make the decision and the impairment. So there's no requirement for the court to formulate precisely what the underlying condition is. So we've now understand, don't we, that we don't look at the impairment first, we look at the kind of functional stuff first. So that's a really good, this is a good sort of demonstration of that, really, that the functional stuff is done first, and then the judges pull together the kind of rationale for why there might be an impairment. She doesn't suffer from a recognised psychiatric or psychological illness, but on the balance of probability, she's got an acknowledged vulnerability. She's been adversely impacted by the trauma of her initial admission to hospital, and that trauma is likely to have been exacerbated by the length of stay, a year in an intensive care unit where actually people around her are dying. So it must be an incredibly terrifying and traumatic environment for anyone, but somebody who's young and doesn't want to die. She's had a year of an intensive medical and surgical interventions, which are painful and distressing. She's terrified of the prospect of dying. I've read the whole case, and she's a highly anxious young woman, and she just clings to the hope that she can survive. But the judge said in this case, the cumulative effects of those circumstances over a prolonged period have actually had that impact on her and impaired her functioning. So on the balance of probabilities, he said that she lacks capacity to make decisions around a continued care and treatment. And he also said that for much the similar reasons, that she would lack capacity around capacity to litigate. So I don't know what the outcome is, because actually that would have gone back to the trust to make a best interest decision then. So I can't tell you what the outcome is, but really, really sad case, but some interesting learning for us nonetheless. And then just 5 minutes to do my last case. Yes, so I was just saying this. So that was a very fact-specific case, but I think, you know, all cases are fact-specific, aren't they? And I think the more you look at case law, the more you realise that, but you can take out those common themes. And I liked the fact that we don't have to cling to a formal diagnosis, and I like the reflections on the unwise decision as well. So final case. Again, I picked this because it's a really interesting case, and I think it's one that kind of challenges us as professionals to really think about the impact of what we're doing sometimes. Again, sort of sad circumstances really. So this is a 30-year-old young woman who's got Down syndrome, a moderate to severe learning disability and autistic spectrum disorder. She's a very accomplished swimmer. She's competed on a national and European championships. She's an actress, and she apparently appeared on a TV soap on a regular basis. So I couldn't work out who she was, but I was intrigued to try and work out. She lives in supported accommodation, which is called Castle Hill for the purposes of the case. It's not Castle Hill. There was a Castle Hill care home in Bournemouth, but it's not that. But she's been there since 2015. The judge has previously made determinations that she's got capacity to engage in sexual relationships, to make a decision about remaining at Castle Hill, and decisions about what care and support she needs on a day-to-day basis. So she's already been through court once, and then this kind of comes again. So the court are now being asked to make a decision about contact, and it's contact with her family. So I'll tell you a little bit more about that in a second. But if the judge was found that she had capacity in respect of making a decision around contact with her family, was then asked to look at inherent jurisdiction instead, and also to make a determination about the capacity to revoke a power of attorney for property and affairs and health and welfare. So the judge was being asked to do quite a lot of things there. So just to give you a little bit of background, she's lived at Castle Hill House since 2015, and between then and 2020, arrangements for regular contact with the family ran relatively smoothly. So she went home, she went to Christmas, birthday parties, had visits, all those kind of things. But it's sometime between 2018 and 2019, she formed a relationship with SA, another male resident. That has now ended. But the relationship generated a lot of distress and dispute for her family, both between the family and the care provider, because they weren't happy with the way the care provider had managed that relationship. So during the second lockdown, so during the first lockdown, RK went back to live with her family. But during the second lockdown, she refused to go back and live with her family. She couldn't be persuaded to do so. And this really, I think, triggered a lot of distress. She went on to really cut off all contact with her family. So she left the family WhatsApp group. The family felt that she wouldn't have done that without help, that somebody must have done that for her. She rarely responded to text messages, emails, and she initiated no contact with the family. If family or friends visited, she would make herself unavailable. She missed birthdays and Christmas, and those are things that she would never have previously done. There was an attempt at mediation, but it didn't work out and contact wasn't resumed. And the relationship for RK's parents and the care provider had really broken down quite vitriolically, resulting in them making accusations of financial abuse and sexual abuse, because she was having a sexual relationship with her boyfriend, and that led to some safeguarding issues being raised by the family. The safeguarding allegations really were about that she'd been able to stay in his bedroom overnight. The family was so distressed about this, they actually called the police, and this was, I think, was a genuine unintended consequence. But the police actually went round to the property and they interviewed the couple. Now that wasn't something that, so 2 police officers literally rocked up in uniform and interviewed them about their sexual relationship, which wasn't at all appropriate, and it caused a huge amount of distress both to both of them and both RK and SA and also his family. The family accused the care provider of financial abuse, and that was something that had been previously investigated and resolved. And they thought that the care provider was coercing and controlling RK and stopping her from having contact with them. They were concerned about her weight gain, and they were concerned about a foot injury that they hadn't told them properly about. RK very angry with her family, particularly her mother. She was blaming her mum for calling the police, which wasn't actually true, but so she's very angry, very upset and distressed by this whole thing. So she met with the judge, and she also wrote the judge a letter setting out her wishes and feelings. She'd had 2 previous capacity assessments which were actually conflicting, but a psychologist found that she had although she did have empathy towards her family, she was very hurt and angry with them. It wasn't found that the care provider was influencing her. In fact, quite the opposite. They found the manager of the care home tried her level best to try and mediate for them, really. RK was really unhappy about the court proceedings. She was finding them really stressful, and this is the bit that I think we need to learn from. She was really upset about the fact she had repeated capacity assessments. So she was constantly being reviewed and capacity assessment, and it led her to feeling that her views counted for nothing. She wanted to spend her money on what she sees fit. She didn't want a family imposing rules on what she can eat, and she certainly didn't want them imposing rules on who she should or shouldn't have relationships with. As I say, the court previously found that she had capacity to have a sexual relationship. The family hadn't intended the police would interview her, but that blame was there. The relationship the two have now ended. I suspect that that's possibly something to do with this intrusion. The court did say that because the family became unhappy with the care provider, RK probably picked up on it as a background issue, but they didn't think that the staff acted in a way that would sap her of her free choice. So they didn't find that the care provider acted inappropriately. So the two, I'm trying to whiz through because I appreciate we're running out of time and you've probably all got places to go. I really liked what the judge said here. He said this independent and free spirit, this determination to set out her own store has been continuously undermined and undervalued time and time again. She's been assessed, questioned and interviewed repeatedly over the same issues, which have left her feeling that her words and feelings count for little, that her views have been ignored, diminished, her experiences, her feelings, and more importantly, her own decisions have been disregarded. I think the judge was quite impressed by her, I think it's fair to say. He found her to have capacity about contact, and felt that she'd really been caught in the crossfire between her family and the care provider. There was lots of other detail about whether she could carry on living there or not. And he did say that she probably did say what people wanted to hear at the time they were talking to her, but didn't think that in itself was evidence of a lack of capacity, but more, because of the general pressure that she found herself under. So he found her to have capacity. He then went on to consider inherent jurisdiction and to prove that she is to go through inherent jurisdiction. He was saying it has to be proven that she's being overborne by the people caring for her and that she's subject to constraint, coercion and undue influence. And he rejected that. He said, no, that wasn't true, and that wasn't evidence, and that she's been making free choices. So there was no jurisdictional peg on which to hang any ruling. I love that saying. So he wrote a lovely letter to her telling her that the court case was ended, that nobody had authority over her decision making around her health and welfare. I thought it was really interesting, the judge, but did go on to say that her family love her and they're sorry, and kind of urging her to have contact, but that reassured her that everybody's happy for her to live in where she is. So it kind of ended in a good place for her. I just thought it was really interesting. The judge couldn't resist that little paternalistic, yeah, but your mum and dad really love you. And they do. Clearly they do. So she is going to continue to live in that home and live her life as she sees fit. So, wow, we almost came in on time. So I'm really sorry that was a bit rushed at the end. Obviously, you'll get copies of the slides. we again really value your feedback. We picked the topics for today from the feedback request that you gave us last time. We're probably a little bit over ambitious trying to do all 3 topics in 1 hour. So if there's anything that you want more detail on, or any other aspects that you want to talk about, please give us that feedback. We do really appreciate it. So thank you for your attendance today. We were up to about 70 people at one point, so that's really pleasing to see that you're all still there. We probably won't be having a webinar in October, but we will have another one in November, and probably the great Christmas quiz at Christmas. So thank you so much for coming, and thank you to Natalie and Val, my colleagues, for their input as well. So thank you.